He was located with meth crystals in his beard as they're executing the warrant. And then there was a little bit more meth found, and ultimately he admits to that. Right? He's like, "Yeah, I've got the meth crystals in my mustache."
The cases are in front of the court today for sentencing hearing. Defendant having entered pleas of guilty to F3 tampering with evidence and F5 aggravated possession of drugs. In count, or excuse me, case 25 CRI 127, defendant entered pleas of guilty to 2 F2 aggravated trafficking counts and 1 F3 aggravated trafficking counts. Attorney Pyle, did you receive a copy of the pre-sentence investigation?
I did, and I read it, Your Honor, regarding both cases.
All right. Is there any reason sentencing should not proceed?
I'm sorry.
Is there any reason sentencing should not proceed?
No, Your Honor, we can proceed. I am trying to turn up the volume a little bit.
They were having problems with that earlier. I'll try and speak up a little bit. Is there anything you wish to say on behalf of your client?
Your Honor, I'd like to bring a couple of factors to the court. First of all, I want to again repeat how grateful Damien and his mother are that you allowed him to go to his father's memorial service. Obviously, he returned as ordered by the court. And regarding the mitigating factors here, Your Honor, number one, I think it deserves considerable weight as it relates to the schoolyard spec, that it was the informant who suggested the place where they meet at the Circle K, which is near the St. Edward's School. It wasn't Damien who wanted to go there. It's not a sufficient defense, I understand, but I think it is mitigating, particularly when we consider the policy and purpose behind the schoolyard spec, which is that you just obviously you don't want people selling drugs near schools, but when the location is suggested by the informant, I think that puts it in a different context. Next, I really don't think Damien's record is that substantial that it would warrant a substantially more than minimum sentence here. I mean, he did have the prior, and he did do, time on it and so forth, and he wasn't compliant with the treatment program after he left the community-based correction facility. I understand that, but relative to other people and relative to the length of sentence, I think that's mitigating. He has no juvenile record. He had a chaotic childhood, Your Honor. I don't think there's any question about that. His mother wrote you about that, and so did Damien. All in all, Your Honor, I think we really should be thinking about close to a minimum rather than more than that, and within the context of this particular case. And I know Damien has some things he'd like to say too.
Mr. Vandries?
Yes, sir. Lost a lot in here. Lost my dad, my uncle. It's definitely opened my eyes up to everything, and I'm just trying to be a better parent to my son. And I just want to take advantage of everything I can to better myself, whether it's in prison. I want to take everything I can to better myself and seek help when I get out too. That's all I got. Thank you, Your Honor.
Thank you, Mr. Vandries. Mr. Metcalf, anything on behalf of the state?
Your Honor, I've had a chance to review the pre-sentence investigation in this case, as well as looks like a letter from the defendant. I hope the defendant is serious and wanting to do better in prison, and once he gets out, hopefully we won't see him again. But this is going to be the third time I think that he's went to prison for methamphetamine. These are mandatory prison offenses, is why I say that. Unfortunately, his behavior is kind of escalating. It goes from possession to now trafficking within a school zone, and it is bulk amount. That's what makes it the second degree felony. That's what brings it into the mandatory prison sanctions. The court's aware. I think the pre-sentence investigation does a pretty good job of relaying the facts in all the scenarios. As far as the CI setting up the buy, I mean, that's true. It is what it is. The CI also is the one who determines the amount. Nonetheless, the defendant's the one who will sell the drugs at that location. And it is within 1,000 feet of the school zone. And he's the one selling that amount of drugs. He's facing, and in this, it's a lot, but in the buys alone, in the 3 controlled buys alone, which there's the 3 of them, and I'd submit to the court that none of them should merge. They're all different dates of offense on those. But in the 3 buys alone, he's facing 19 years in prison. And that is a very long time. Then they execute the search warrant on his house. At that point, the tampering and the possession of meth. I believe Mr. Vandries was actively trying to use meth during the search warrant, or while the search warrant's being executed, while cops are at his door. He was located with meth crystals in his beard as they're executing the warrant. And then there was a little bit more meth found, and ultimately he admits to that. Right? He's like, "Yeah, I've got the meth crystals in my mustache. I was trying to get rid of them prior to you guys coming in," and that's what happened. So we look at Mr. Vandries. He's got 2 prior felonies for possessing meth. He went to prison on both of those, and he's facing a significant amount of time on these. I don't have a number, I guess, to recommend to the court as far as what type of sentence would be appropriate. Although I do think consecutive sentences would be appropriate based on all 3 offenses being different actual offenses, different offense dates, different drug transactions conducted by the defendant. And then the search warrant itself obviously is a completely separate transaction with the tampering with evidence. That's really all we're asking, Your Honor, is that Mr. Vandries receive consecutive sentences in these matters. It is pretty serious stuff. That's why it comes with mandatory time. I think the PSI does a decent job of, as I said, laying out all the facts and what happened in the drug transactions. He did accept responsibility for all of this. He has pled to it. But nonetheless, it's pretty serious stuff. And we're asking that the court impose consecutive sentences on the counts that he pled to in 1, 2, 7. So I believe that's count 1, 3, and 5. And we'd ask that be consecutive to any sentence he receives in 25 CRI 116. As far as the tampering and the possession of drugs, there is money that needs to be forfeited to the state as well. In that case, the state's asking for forfeiture. There was a forfeiture spec. I mean, he possessed meth and he destroyed meth at the search warrant. So he did do both of those, all within the same day. Ultimately, we were asking for consecutive sentences, though, from the court.
Your Honor, may I be heard again?
You may.
Your Honor, in regard to the argument for consecutive sentences, it's a fact of life that in situations like this, the state could have the same informant make multiple buys, just not 2, not 3, but more than that. I mean, they could drive a sentence to, close to a life sentence just by letting an informant make multiple buys. And it's the same in this case. It's the same informant. It's essentially the same amount. I just don't think that warrants consecutive sentences. And the other thing is, Your Honor, Mr. Metcalf and I believe we agreed that it should be brought to the court's attention that Damien offered to work for the prosecution, for the police, and in whatever way he could do something, even if it's just information. But that offer was turned down. So I think these are all factors that we hope the court will consider.
Thank you,
I can
Mr.
confirm that, Your Honor. That is something that was discussed, and ultimately the state did turn that down.
All right, the court has considered the pre-sentence investigation, considered the case history here, statements of counsel and the defendant. I do find I understand you have no juvenile record, but your adult record is concerning. Starting in 2019, you had possession of drugs. You were granted intervention in lieu of conviction for that, which you violated. You were then ordered to complete Crossway and placed on community control in that case. But you violated your community control and you went to prison for 11 months. 2023, you had another aggravated possession, and at that point, got another 9 months of prison. And then in 25, you end up with these cases. It's concerning because, one, it shows an escalating conduct here. You've gone from just possession to now actively trafficking. You've had repeated trafficking. I understand Mr. Pyle's point about multiple lies by a informant, but those don't merge because each act of selling is just that. It's an act of selling drugs. It is within the range of a school, which increases the significance or the seriousness. There's a reason for that law. The legislation tries to limit the exposure risk to children. Methamphetamine itself is a dangerous drug. People use it, they get delusional, they harm other people. They also harm themselves. So it's a dangerous drug, and there's a reason the legislative body doesn't want it near kids. This did happen over the occurrence of multiple dates. Then when they go to execute the warrant, there's the ingestion of the drugs. So there is some mitigation here on your behalf, Mr. Vandries, but there's also a lot of seriousness factors that the court cannot ignore. And the fact that the prior prison sentences haven't deterred your behavior. Your behavior continues to escalate. So the court, well, in case 25 CRI 127, in finding that prison is mandatory in that case, in 25 CRI 116, I'm finding it's not mandatory, but you're not a candidate for community control, and community control would be demeaning to the seriousness of those offenses. Court is going to order as follows. In 25 CRI 116 on count 1, court's going to order that you serve 6 months in appropriate penal institution. With respect to count 2, tampering with evidence, the court's going to order that you serve 18 months in appropriate penal institution. I am ordering the forfeiture of $292 in currency to the state of Ohio in that case. In 25 CRI 127, on count 1, aggravated trafficking in drugs, court is going to order that you serve a 3-year minimum sentence, which would create a maximum sentence for that charge of 4.5 years. With respect to count 3, the court is going to order that you serve 3 years in appropriate penal institution, again, making the maximum 4.5 years. With respect to count 5, the court is going to order that you serve 12 months in appropriate penal institution. I am finding, Mr. Vandries, that consecutive sentences are necessary to punish the offender and protect the public from future crime and are not disproportionate to the seriousness of the conduct and the danger posed by the defendant. The 2 or more offenses were part of one or more course of conduct and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct. I'm also finding that your criminal history demonstrates that consecutive sentences are necessary. Therefore, I am ordering all of these counts be ran consecutive to each other, which would make your aggregate sentence in 25 CRI 116 24 months. That would make your aggregate sentence in 25 CRI 127 6 years, 12 months, or 7 years, to a maximum of 7.5 years, 12 months, which is the equivalent of 8.5 years. Altogether, that would make your total aggregate sentence essentially 9 years to 10.5 years. You do have, by my calculation, 286 days of jail time credit as of today. You will continue to earn jail time credit until you're transported to the Department of Rehabilitation and Corrections. While you're there on the non-mandatory terms, you may be eligible to earn days of credit. Those are not automatic, however, you have to earn those through participation in various programs that are offered and sanctioned by the department. As I said, you are receiving a minimum and a maximum term. It is presumed that you'll be released at the end of your minimum term. That presumption can be rebutted by the Department of Rehabilitation. They can hold hearings, make certain findings regarding your conduct while confined, any security classification you have, any threat you may pose to society, if you are in any restrictive housing, and they can rebut that presumption. If they do so, they can hold you beyond the end of your minimum term. They can do that process more than once. If you reach the end of your maximum term, you would then be released at that point. You will be subject to a mandatory term of post-release control. It is mandatory in your case for a period not less than 18 months and not more than 3 years. What that means is the adult parole authority will supervise you following your release from prison. You will be subject to rules. If you violate their rules, they can send you back to prison on a rules violation. For up to 9 months at a time. They cannot exceed more than 1/2 of your originally stated prison term for all violations. Given your indigent status, the court is not going to assess the mandatory fines on these counts, and however, assessing court costs to you. I'm also not going to assess a license suspension given your length of incarceration. If I missed any items referenced for forfeiture, those are to be forfeited to the state of Ohio. You do have the right to appeal my decision. Any notice of appeal does need to be filed within 30 days of the court's sentencing entry. If you're unable to afford an attorney for an appeal, one can be appointed to represent you if you're found to be indigent upon your request. Likewise, the cost of an appeal could be paid out of public funds if found to be indigent. Do you have any questions about your sentence, Mr. Vandries?
No, sir.
Mr. Pyle, anything further?
Your Honor, in light of the volume issue on this computer, the minimum sentence is what? The minimum before the add-on?
All together?
Yeah.
Just a minute, I had it here. It would be 9 years to 10.5 years.
Okay. And then the jail time credit is what?
286 days.
Okay. Okay.
Mr. Metcalf, anything further?
Your Honor, I was just curious if the jail time credit's being applied to any specific case.
We'll apply it to the first case, 25 CRI 116.
Okay,
Thank
that
you.
was it.
All right. Bond conditions will be released upon journalization of my judgment entry. Pre-sentence investigation will be filed under seal. Mr. Vandries, you're remanded to the sheriff for transport to the Department of Rehabilitation and Corrections.